Alright, so you guys, I think I've told you a whole lot about Kelo v. New London by now. Property takings, eminent domain, higher taxes, expanding the Fifth Amendment in ways that give more power to the government. You know the drill. Sweet. I want to address something that Jack brought up last time, which was a pretty fair point, that the decision is still pretty recent. It happened in 2005, so how do we know it really matters when it hasn't really had a chance to do a whole lot yet? Two words. Stare decisis. And those are Latin, in case you couldn't tell. And what that means is that when things are decided by the Supreme Court, they stand as precedents. And you're not supposed to rule against precedents because, you know, if the same issue's already been decided, why would it be different later in time? That's pretty important here because, you know, the Kelo decision will probably stand for a long time to come. Look at how long Dred Scott mattered, or Plessy v. Ferguson. Terrible decisions, but they stuck around for a while, and who can really measure the untold damage that a decision like Plessy caused? Hard to say. Same goes with Kelo. We might never really know the true extent of the harm it caused, but I guarantee you, it will be great. Do I have time left? Cool. Brandenburg v. Ohio doesn't really matter because it's kind of the same as every other First Amendment case ever. Of course unpopular speech is protected. That's why it's free speech. If only popular speech was protected, it wouldn't be called free speech. Game over.
Say hi. That is a good question. Yeah, I didn't hear what you said altogether, but that was a good question.
I'll be honest, I wasn't listening.
Aren't you smart?
He's sitting like us.
Yeah, he said that my court's case doesn't really matter. First off, I'll just say mine's Ku Klux Klan, speaker, blah, 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 told you a bunch. The thing about my case, though, even though there are a ton of them about the First Amendment and dealing with that, my case ended up creating a process that helps to clarify which speeches can be considered not within the free speech range. Number one, speech can be prohibited if it is, quote, directed at inciting or producing imminent lawless actions. And two, it is likely to incite or produce such actions. These were created after my case because Brandenburg was originally imprisoned because he was taken under charges that were a Ohio law that had been passed, which the Supreme Court found unlawful, and because that law was too broad, so it basically came up with this process. That way it is a little bit more narrow, and it was basically just better for use all around.
I need my podium.
Podium sucks.
It's always been true that speech that incites violence is not protected. That's just been around forever, so again, not really relevant. And if it wasn't Brandenburg, it would have been one of the other 20 billion cases that are exactly like it, like Skokie or something else. The point is, Brandenburg really just clarified things that are already around. Kelo v. New London basically opens up a whole new world of possibility as far as the government creating eminent domain takings and, you know, taking people's land with really little to no justification. Property seizures all day.
Every day?
Go team.
Go Jesse. Need my chair. Alright, basically what Nick keeps saying is that his case is going to be something that could possibly create all these awesome new decisions in the future. But what we're trying to do is find the most significant case. His so far has dealt with that one instance and really nothing else since then, as he's told us. It could do stuff in the future, but we don't know that yet. There are significant possibilities of that happening, but it hasn't happened yet. This has happened before, has happened since then, so it's more significant.
Alright, how many of you thought Nick in his defense of the Kelo decision was more persuasive? How many of you thought Jesse was more persuasive?
Love you, Jesse.
Okay, the class votes for Jesse. Senator Hensley. Let me go first.
How did you know?
Flip a coin.
I'm going to go with Nick and his arguments about stare decisis, and this is a scary precedent for a long time.
I feel like procedure. I'm gonna go with Kelo.
Alright, so that leaves us with 4 cases. We've got William and Rothschild debating each other about guns, and Joseph's just not going to talk about his case, he's going to talk about William's stuff.
Talk about me for 5 minutes.
And Nick's Kelo case versus Avery and his
Can we have more time?
marital rights
20
case.
minutes and 2 minutes? No,
Yeah.
since it's semifinals.
No.
Oh, come on.
I'll give you more time on the final.
Okay.
Okay.
I'll give you more time for the last one.
No, we should just have 20 minutes.
That works.
Just 1 minute. Just multiply by 10. Done. 3 and 2. That's about 3 and 1. We should vote. 3 or 2 and 2. 2 and 2 would be good too.
Jack.
2 and 2 would be nice.
Jack. He was under hour and 7 minutes.
Alright.